There are obviously certain things that should be disclosed from a legal standpoint. You know, if the business is involved as a defendant in any type of legal action, that should be disclosed. Now you could say, well, you know, the prospective purchaser could do the due diligence and do court record search, but what if it's out of the jurisdiction? You can't search everywhere if you're a potential buyer. So those need to be disclosed. Plus there might be ones that are right on the cusp of litigation and the seller knows that there's this highly likely exposure via an upcoming lawsuit that is going to be filed or is in the very initial stages. So those things need to be disclosed. Obviously, you know, the financial information that is given has to be accurate. Now, certainly, when presenting an offer to the buyer, the seller is presenting the business in the best light possible while making those disclosures. Then you have, if there's real property involved, you get kind of more in the real estate end of it than you do in the business law end of it, which is to say that you have certain disclosures that you have to make with the building. You may have certain kinds of relationships, whether it's family or otherwise, that need to be disclosed, especially if the potential purchaser is going to take on new employees, and there are going to be people that are going to be necessarily loyal to the seller, such as a family member. Maybe it's a cousin. They don't share the last name, and the person that's taking on that employee has no idea. And if there's some type of ongoing relationship between the buyer and seller, in other words, everything is not just cut and dry, done at closing, which most people expect and sometimes happens. But in business sales, it's a little bit different, and sometimes there are ongoing relationships between the buyer and seller with the contract. And so there are necessarily disclosures that may have to be made on that particular end, so that the buyer all of a sudden doesn't say, wait a second, if that had been disclosed to me, I never would have agreed to this. And a judge or jury may agree with that. So you need, the first thing is I talk to clients and tell them that, and this really kind of goes with any area of law, and it should go without saying, but it really can't go without saying, and that is that the clients need to be honest with the attorney. And some things may need to be disclosed and some things may not need to be disclosed. And that's one of the reasons why you have counsel, so that we can guide the seller through the process and say, okay, well, I know you don't want to disclose this, but you have to disclose it, and it's really not going to hurt you so much because we can mitigate it with A, B, or C, or it's just out there, and yeah, you may take a monetary hit on the sale, but you're not going to have to worry about being sued in the future. And you can sleep at night and you can look yourself in the mirror because you know that you did the right and ethical thing, but more importantly, to some people, you've done the legal thing, so you've limited the legal exposure that you have. So all those things kind of need to be analyzed by an experienced attorney that handles these types of business sales, and then guide the seller in regard to any kind of disclosures that need to be made.